welcome to Newsclick. Last week, our Parliament passed the Mines and Minerals Development and Regulation Act, which is supposed to ensure transparency in the allocation of mineral resources in India. The passage of this act must be looked at in the context of the coal and 2G scams exposed during the UPA regime and the Supreme Court decisions that ordered auction of vital natural resources. In the coal scam, it was estimated that the country lost an income of something like 1.86 lakh crore due to about 200 coal mines not being auctioned, but instead being handed over to private companies. The present legislation is therefore in theory supposed to ensure that other minerals are brought under a similar regime to coal and that auctions are made mandatory for all other minerals mined in India. To discuss the legislation, we're joined by D.Raghunandan, President of the All India People Science Network and associated with the Delhi Science Forum. Hi Raghu, and thanks for joining us today. Now, the bill, which was actually an extension of an ordinance that had been promulgated previously, was, it's claimed, passed to ensure greater transparency and to remove government discretion in the disbursement of or allocation of precious mineral resources. How does the legislation actually strive towards this end? How does it do this?
Well, firstly, I think one needs to question this idea that this is a genuine rationalization in the sense of a better regulated system. What it does is it replaces earlier discretionary methods of allocation with an auction-based system. However, if you look at the finer print of the legislation, you will find that there is still a large amount of room for discretion in the way this is implemented, apart from the initial auction. So this really does not completely move away from a system, but it deregulates the system and opens it up to some amount of revenue generation to the state and allowing for a bidding process, which earlier might have taken place inside closed doors, but now takes place more in the open. But I think that one should not overestimate the impact of an auction process compared to any other process from the point of view of how a mineral utilization in society is handled or regulated and what benefits does it bring to society either in social terms or environmental terms.
You don't think the market is an adequate way of measuring the value of a mineral?
Precisely my point. In fact, I think minerals are the one area, because they are extractive of what is a capital resource, is precisely an area where far greater regulation is required and where market forces can never be trusted to fully operationalize these mandates.
So while you said that discretion has been reduced insofar as the auction or the handing out of these rights is concerned, but greater discretion, or there is still discretion to the government at other levels. Could you give some examples of this and how this could be misused?
The first thing I think one must recognize is that auctions are perhaps more effective when you know the quantum of either minerals or whatever is being extracted, or of spectrum in a telecom case, and where auction is used basically to discover a price of a known quantum of whatever. The problem in the mines and minerals case is in most of these instances, the mineral deposits themselves are unquantified, they are unknown. So whereas on the one hand you have arguments saying that the state gains a lot of money because of auction, there is an equally legitimate argument to say the state may not be getting enough and that there will be a tendency among bidders who may cartelize amongst themselves and underbid because they have a better estimate of what the deposits actually may be, but they would bid for it assuming and arguing that it's actually a lower volume, and over a period of time. And don't forget, these leases are very long-term leases.
50-year leases.
It's now 50 years, whereas earlier the proposal was to go for 30-year leases. Over a 50-year period, you're talking about super profits, which mining companies can get despite an auction. So I don't think the auction is necessarily a very accurate process of price discovery. precisely because an estimation of quantities would not have been done, which was one of the aims of state organizations which were supposed to be responsible for mines and minerals.
Now, some have criticized the legislation, pointing out the fact that despite what the public has generally been told, that the statute actually excludes large quantities of minerals from the purview of auctions. So it's been estimated, for instance, by some that, say, just in the case of Chhattisgarh, one of the largest mining states in India, approximately 570 million tons of iron ore is being kept outside the purview of auctions, which amounts to a loss of a scarcely believable figure of 1.716 million crore. Yeah. The total losses to the country could therefore be astronomical. I mean, do you agree with this criticism?
Well, yes and no, in the sense that I agree with it to the extent that if you are going to evaluate such legislation by so-called gains to the state from auction proceeds. The same thing could have been done through other means as well of getting money, except that auctions are supposedly slightly more transparent than otherwise. The state could have got revenue through lease agreements or whatever else. What this legislation says is that leases which have already been awarded will not be subject to these auctions. Yeah. So those, in a sense, are a loss if you compare it with this. My argument is that I don't think in this case one should be looking at gains and losses purely from a transactional point of today you are auctioning this and you already have mines which are non-auctioned and therefore they represent losses. Yes and no. To me, there is a far greater social and environmental loss which I'm more concerned about than the monetary gains and losses that we are talking about.
Now, when we're talking about the sort of social side of things, I mean, there's a provision in the Act, for instance, which ensures that mining leaseholders have to pay a percentage of their profits to the benefit of affected people. That's 26% of their profits in the case of coal, and in the case of other minerals, it's equivalent to the royalty they will pay to the government. Do you think that such provisions are workable, are they beneficial, or do you reckon that they are merely eyewash? I mean, they have come in for some criticism from industry bodies who claim it will raise the cost of investment, so on and so forth.
Industries would love to have a system where they would get the mines for free and not pay anybody. Right. So that's all right. But if you look at the legislation which preceded this one, which the UPA government had drafted after a fairly wide process of consultations in the country, but they didn't have the courage to go through with it. Right. The legislation was almost ready even as far back as 2011. That legislation actually provided for the creation of district level funds equivalent to royalty amounts. The present legislation has reduced this from equivalent to royalty to 30% of royalty.
In the case of coal.
So it actually reduces it by 70% compared to what it would have been earlier. Secondly, the amount of money thus earned in the earlier legislation had been slotted for expenditures in the impacted district, which, as you would know, in most mineral cases would be in forested and tribal areas, with most backward regions, with the most backward people. Displacement takes place maximally there, and if this fund had been invested for developmental purposes in that district, that would have certainly gone some way towards compensating the people there, or ensuring that they are to some extent at least beneficiaries of this project. The current legislation takes this fund and puts it at the disposal of the state government, which the state government can then decide what it wants to do. It can do whatever it feels like, not necessarily in the affected areas and not necessarily to benefit those people living in the areas from where the minerals are being extracted. So the local people, the tribal people, the forest areas are not beneficiaries of this scheme anymore.
Why the government was in such a rush to pass through this bill? There was barely any discussion on this in this session of Parliament. There were suggestions that it should be sent back to a standing committee for re-examination, which were not heard by the government. Do you actually think that the way the bill is currently, or the act is currently drafted, it will encourage cheaper and easier access to raw materials for industry and therefore promote the development of India, of the Indian economy? And so in that sense, do you think that there's some benefit to be gained?
I would look at it like this. If you see that more private investment will take place in the mining sector, in extractive industries, yes, mining would attract more investment because the present legislation allows greater freedom. It dilutes the environmental legislation. It dilutes expenditures to be incurred by the company on royalties, etc. Gives a longer lease from 30 years to 50 years, allows for greater profit earning by the company. So naturally, this is a pro-corporate legislation.
Right.
Corporates will gain. It paves the way for deregulation of the mining sector. One of the big demands by the opposition, particularly by the left in parliament, was that along with this bill, there should have been greater measures for regulation of these industries, compared to which you have actually got now more or less a laissez-faire system in work. So corporate sector will certainly benefit. It will show up in GDP growth numbers, but I think society will lose big time in this from two major counts. One is, as I was saying earlier, the local areas will not benefit from this legislation. Environmental costs are going to be very heavy. There is no now provision for obtaining environmental sanction before a project is launched. The reply by ministers in parliament specifically said that cannot be done because environmental clearance depends on you providing details of mining operations, etc., which you can do only after you've started. So the idea is you start mining and then you apply for clearances, after which then clearance becomes a formality. Secondly, you've got a provision now, you've got a 10 square kilometer area where the lease is given, but this can be extended without much formality, without having to go through another regulatory process. So it further deepens the area which can be deforested, where people can be displaced, where environmental provisions may not apply. And the worst irony, I think, of this is the rest of the world is going towards modernizing the mining industry to make mining more sustainable, if that's not a contradiction in terms, but to modernize it, to make it reduce its ill effects, to make it safer for workers, to protect workers' interests. The current legislation makes no provisions along those lines at all. So it's only concerned with money making by industry and attracting investments. So I think if I were to sum it up, I'd say this would have short-term gains for corporate sector, short-term boost for investment in the mines and minerals sector, but it will have long-term very deleterious consequences, both socially and economically, particularly if you take into account environmental costs.
That's all the time we have today. Thanks for joining us, Raghu, and thanks for watching.